Most workplace investigations start because of suspected wrongdoing by an employee of the organization. Claims of wrongdoing can be brought to the employer's attention by not only formal and informal complaints, but also information obtained during exit interviews, anonymous tips, rumors, third-party information, and many other means. A workplace investigation is not an effort to prove or disprove allegations, or to determine whether allegations are true. A workplace investigation is designed to find facts and to determine what happened or what's happening in the situation. An investigator for the organization has the responsibility to look beyond the simple incident or accusation to examine the situation as a whole. The first step in any investigation is to determine who will investigate the allegations. Before making this decision, it's important to check the employer's policies to see if they address who should conduct an investigation and how the process should move ahead. Some key questions in determining an investigator are: is anyone with the organization trained to conduct such an investigation? Are there one or more employees who come to mind as credible or who'd be able to gain the confidence of employees involved in the investigation? Does the investigator have the time to conduct a prompt and thorough investigation? What are the charges? Can the anticipated cost be balanced with the level of seriousness or the activity that allegedly took place? Who is implicated in the charges? Are any supervisors or managers involved? Is this employee a union member? Is the employee a qualified veteran? Does the matter to be investigated involve possible criminal behavior? And if so, the organization may need to defer employment investigation and consider referring the matter to a law enforcement agency for criminal investigation. And finally, if there's been threats of violence or other illegal activity such as theft, law enforcement should be contacted. Regardless of whether the employer chooses to work with an external consultant or use an internal resource to conduct an investigation, there are certain things the city should look for in an investigator. An investigator should be familiar with the agency's policies and have sufficient experience to conduct the interviews and present recommendations to management. The investigator should not have a connection to the individuals or the subject matter of the investigation. This could call into question their integrity or the integrity of the investigation. Neither the complaining employee nor the alleged wrongdoer should have a direct subordinate of the investigator. Likewise, employers who do not want to choose an investigator who is a family member or a close personal friend of a complainant, witness, or anyone else involved in an investigation. There are many things to consider when deciding how to conduct an investigation. One of the most important is interim actions. If the investigation is based on allegations of harassment or threats of workplace violence, the employer should give consideration to whether interim actions should be taken during the investigation period to separate the parties involved. Advise the complainant that the agency will be investigating the complaint and generally what that investigation will include. Inform the complainant that information provided will be kept as private as possible, but they cannot guarantee confidentiality. Also, stress to the complainant that he or she is not to discuss the investigation with others to avoid appearance that he or she is trying to influence the investigation. The complainant should also be advised that the agency will not tolerate any retaliation for reporting the complaint. Depending on the circumstances surrounding the allegations of wrongdoing, an agency may or may not need to provide employees with a formal notice prior to questioning them. The TENNESSEN warning is required under Minnesota Government Data Practices Act. It's given at the point of data collection whether the agency requests private or confidential data about an individual from that individual. When collecting private or confidential data on employees, an agency is required to provide a warning or notice to the employee of why the data are collected and how it intends to use the data, whether the employee can refuse to supply the data, and any consequences of either supplying or refusing to supply the data, and finally, the identity of the other persons or entities authorized by law to receive the data requested. If the employer does not provide a TENNESSEN warning but collects private or confidential data, strict limitations may be imposed on the use of that data. It is important to note the circumstances requiring a TENNESSEN warning are limited to those in which an agency is requesting data about the data subject from the data subject. It does not apply to situations in which the agency is asking an employee to provide other information, such as a description of events witnessed by an employee or information on other employees. The investigation interview should be held in a location that's quiet and where the investigator and interviewee are unlikely to be interrupted. The general facts of the matter and strategies being considered should not be discussed with any interviewee. Not only could this information confuse a witness, it's possible the witness would share such information with others who are not legally entitled to it. Sharing information could also jeopardize the validity of the investigation results by letting witnesses hear information that influences their responses. An investigator should use a variety of questions and with some repetition to test credibility of a witness. Legal jargon should be avoided. If the interviewee is a union member, the employee may have the right to a union representative to be present. This is sometimes called the Weingarten Rule or Weingarten Rights, from a U.S. Supreme Court decision of the NLRB versus Weingarten, which addressed, among other situations, when union representatives may accompany an employee by an investigatory interview or a discussion that employee reasonably believes will result in disciplinary action. The purpose of interviewing is simply to collect facts, to collect information. When determining the best order in which to interview individuals, it usually makes sense to start with the person making the complaint. In general, interview people most directly involved and the most likely to provide highly useful information first. The investigatory interview conducted with the complainant will be different from the interview conducted with an accused employee. Likewise, interviews conducted with witnesses will be different from those conducted with complainants or the accused. It is important that the investigator prepares for each of these meetings in advance. The classification assigned to data generated by an investigation is generally private while the investigation is ongoing. That classification may change for some of the data once there's been a final disposition of disciplinary action. Such data will generally remain private, however, if no disciplinary action is taken. There are some situations in which the data will be classified as confidential and not available to the subject of the data. When a public employer concludes an investigation but takes no disciplinary action against the employee, only the limited data regarding the existence of the complaint and its status are public. All other data remain private, and no further data regarding the incident may be disclosed, including the employer's reasons for not taking disciplinary action. Minnesota law indicates the following information become public after the final disposition of any disciplinary action: the disciplinary action itself, the specific reasons for that action, and data documenting the basis of the disciplinary action, excluding data that would identify confidential sources who are employees of the public employer. For any particular event, there are three possible conclusions: the event occurred, the event did not happen, or you're unable to determine if the event occurred. In addition to evaluating the information obtained during the investigation, follow these steps in making a decision. Review personnel files to understand past behavior and performance. Consider further meetings with direct supervisors or managers regarding behavior or work performance. Evaluate whether any laws are violated. Evaluate whether the events actually occurred as the allegations suggest. Remember, it's all about reviewing the facts the investigation finds. And finally, figure out whether there's any other necessary actions to be taken, or if a conclusion is possible.